It turns French citizens, and not only them, into defenseless subjects, deprived of free will. This is a cruel discrimination against freedom of speech, and, above all, freedom of thought. Fear-mongering of people's differences is what anti-cult organizations do. The activities of anti-cult organizations form attitudes of suspicion, intolerance, and of course, anti-democratic sentiments. After the verdict, one believer who was present in the courtroom broke into tears and confessed to me that she cried because her self-identification had been restored. These were tears of relief.
Welcome to the Creative Society channel. The topic of our interview today is freedom and democracy. We have the pleasure of speaking with lawyer Fabrizio D'Agostini, an expert and respected attorney, scientific advisor, and founding member of FOB, European Federation for Freedom of Belief. Recently, attorney D'Agostini recently gave a very strong and well-reasoned opinion about a new law passed by the French government regarding the criminalization of psychological influence. But before we delve into this discussion, I would like to give our listeners a chance to get to know the lawyer. Attorney, could you tell us a bit about yourself?
Yes, certainly. I was born in Turin in 1945, Turin, Italy. I am the third of 6 children, and I graduated in law, specializing in the philosophy of law under the guidance of Norberto Bobbio. Due to financial reasons, I left my job at the university and focused on my professional activities. First, I worked as an intern, then as a novice lawyer, and eventually as an attorney. I was involved in significant criminal trials. In the early 70s, I finally left criminal law and focused on civil law. Until 2015, I practiced solely in this field. In 2015, I, along with others, helped establish the European Federation for Freedom of Belief, FOB, and remained on its board of directors until 2020. I continued to participate in FOB's scientific committee. In 2018, I organized and participated along with many others in the international conference, Law and Freedom of Belief in Europe, an arduous path. At the conference, I moderated the 3rd session. The conference was awarded the Medal of the President of the Italian Republic. In 2018, due to physical reasons, it was spinal surgery. I gradually ceased all social activities and resigned from the FOB board. However, I continued to write. Between 2010 and 2018, I gave lectures in Italy, Belgium, and Florida. As part of my work at FOB, I published articles on human rights, particularly focusing on the right to belief. In my civil law practice, I represented the very small Manichaean Church, now defunct, the Church of Scientology, and the Damanhur spiritual movement. Since 2018, I no longer attend court hearings and am effectively retired. Though, I continue to write and work.
Thank you. That's quite an extensive and interesting background. As you know, we're particularly interested in your open letter as a European Union citizen, in which you express your concern about the adoption of this law in France, aimed at strengthening the fight against so-called sectarian aberrations. Could you explain to us and to our viewers this situation in more detail and help our international audience understand what the adoption of this law by the French government means.
The question actually raises two issues. The first issue concerns why I chose to speak as a European citizen. The reason is the need to abandon the concept of statehood, to stop talking, thinking, acting as if we are in an autonomous and sovereign state, separate from others and not interested in their fate. The notions of sovereignty and autonomy, if perceived as absolute rather than relative, are incompatible with any form of common life, but, on the contrary, contain the possibility of conflicts and war. The issue is certainly complex, and here I speak as a European citizen, not just as an Italian, and this is not just a subjective opinion. This is the objective position of a citizen of one of the countries of the European Union. The second issue concerns the French law, aimed at strengthening the so-called fight against sectarian aberrations. It is difficult to explain this term, since a new criminal article has been introduced. This situation is not unique to France, because similar laws or laws for the same purpose have been repeatedly proposed in Parliament, under pressure from lobbying groups in Italy as well, and with varying success in all the countries of the Union. France is not an exception when it comes to legislative initiatives that, under the pretext of protecting the state, affect society. The European Federation for Freedom of Belief, FOB, has addressed this issue in the past and continues to engage in extensive discussions on it since April of this year. Intravine, Duval, Calceleri, and others are involved in this. It is clear that two articles of this bill infringe on freedom and are unacceptable, Article 2.3 and Article 12. The first one is an attempt to define the criminal offense of psychological impact, while the second concerns the crime associated with the refusal of medical treatment due to that same psychological impact. The adoption of both articles and the law as a whole is justified by the supposed need to eliminate a legal loophole and protect citizens' right to self-determination. But what exactly is the psychological influence that French law recognizes as a crime? Since Vance Packard published his book, The Hidden Persuaders, in 1957, psychological impact can no longer be considered solely as an individual's crime. Today, there is a wealth of literature on this topic. There are manipulation techniques, from advertising to marketing, from various sales strategies to politics and beyond. They have become a fundamental element of modern social structure. And in some countries, it is even regulated. If this is true, then psychological impact, as a crime under French law, targets the manipulator rather than addressing the problem of manipulation itself. This applies to sects, ideologies of minorities, in particular religious denominations that are different from the dominant ones. In particular, but not entirely, because even the dominant religious groups need to be cautious. From a legal perspective, Article 2.3 of the French penal law violates the principle of certainty and clarity of the legal norm. Paradoxically, the law entrusts the judge with the task not to verify the facts on the basis of the evidence collected, but to create the fact of a crime during the trial without taking into account the investigation preceding the trial. Thus, the judicial process, which is supposed to establish the fact of a crime, turns into a process that creates the fact of a crime. There is no psychological impact before the trial. In French law, as in Russia, Japan, Argentina, and China, psychological influence exists when an adept, believer, fanatic, or activist changes his way of life, social circle, and friends. Thus, the subject of the accusation is not psychological influence, which is not considered, but simply change. A change that must be proved by facts becomes a fact itself. How does psychological impact arise if you understand it without distortion? There is a charismatic leader, a guru, and his teachings, as well as someone who follows him, that is, a believer, a supporter, or an activist. And a sectarian becomes a person who follows this charismatic leader or guru. The term sectarian comes from the Latin sect, but belief in a charismatic leader, spiritual leader, and his teachings is not a crime in France and is not persecuted by law as a sect. A real crime is considered if a person changes his lifestyle. That is, the crime is not in the psychological impact itself, but in the change. Minor changes do not matter. Only those that lead to a transformation of the generally accepted way of life and social mores are important. The phenomenon of deviation is persecuted. That is, deviation from the culture and way of life of society. No ideology or teaching, even if it leads to a deep and strong faith, can protect a person from criminal prosecution. The strength of one's faith and the depth of beliefs is another aspect that is the basis for fabricating crimes of psychological subordination. You can supposedly believe, but not so deeply as to change your life. In a sense, this is cruel social conservatism. And finally, France once again demonstrated its legal insolvency when it was ruled through the Maïvelouds agency that the testimony of victims of psychological impact is of no value precisely because it is conditioned by the human psyche, except for those who have departed from the faith or apostates, who are convenient witnesses. The rest are victims against their will, and the infliction of alleged physical and mental harm is presumed, stated and asserted, but not proven. What about the physical and psychological damage that is presumed, stated and asserted, but not proven? If physical harm is found to have occurred, there are other strict sanctions for that. In terms of logic, it is a tautology. There is psychological dependence because psychological dependence really exists. And the fact that the victim says under oath that she is not being affected in any way does not matter. This effectively means the end of personal freedom. Additionally, the judge can only rely on expert opinions. This effectively hands over judicial authority to psychologists, psychiatrists, psychoanalysts, or anti-cult organizations. This is already the third party that makes decisions. What awaits the faithful citizens, those who cannot witness because they have been psychologically conditioned? Then whose will replaces their own will? The national guarantor of the rights of persons deprived of personal liberty, which has been in force in Italy since 2016, stated in his report that psychological manipulation is an impossible crime.
And the next question is, how this law can affect freedom of speech and democracy in Europe and perhaps even in the world, in the United States? How do you assess the possible impact of this law?
This is inevitable, and not only because of the law. These are promoters, lobbyists, politicians, the adoption of documents. This is a whole culture that is not a culture of freedom. Sanctions can be applied for the expression of thoughts, for the choice of a person, for his words, teachings, doctrines, beliefs, and ideology. The theoretical basis of the new norms for psychological violence does not imply any consequences, no real punishment. This is a cruel discrimination against freedom of speech and, above all, freedom of thought. It turns French citizens, and not only them, into defenseless subjects, deprived of free will. This applies not only to a few exceptional cases, it applies to all of them. It is a threat to everyone. This has nothing to do with the democratic culture of France. It's about subordination, about turning a free citizen into a subordinate. And this is not only at the national level, because since the second half of the 19th century, culture has covered the whole of Europe without borders. And today, it encompasses nations and countries, crosses seas and oceans. People of different cultural traditions communicate on social networks, and this is already on a global scale. As already mentioned, there is a degradation of democracy. We have many problems, and not only in France. Since similar bills for the same purpose have been repeatedly submitted to Parliament by deputies who are under pressure from lobbyists in Italy, and with varying success in all EU countries and around the world. They seek to revive the old and bloody European culture.
I think that such a law can also lead to criminal prosecution of a person or making a certain choice. For example, he preferred alternative natural medicine. Can you share how you see the situation in terms of freedom of speech and human rights under this law?
Yes, the new French law, Article 12 of the bill, transferred to the criminal code a dispute that began in the 70s to 80s of the last century. In the so-called New Age, there appeared a number of therapies, both physical and spiritual, mainly of Eastern origin, and therefore they were new to the West. This phenomenon was, in fact, unacceptable to Western medical culture. Anyway, the context of Eastern therapy is different. Since Western medicine is dominated by health and fears surrounding a person. Fear-mongering of people's differences is what anti-cult organizations do. Ultimately, this is no different from the psychological violence that I have already mentioned. Many official medical institutions consider New Age methods of treatment to be heretical and therefore erroneous. The Italian and French laws provide that the patient, informed and knowledgeable, is free to choose the therapy he prefers or to refuse the ones he does not want. This is the embodiment of freedom. This freedom is a constitutional right. French law, in turn, does not prohibit the choice of alternative therapies. There is nothing prohibited in so-called heretical therapies. The use of such therapy is the freedom of choice of a person. Then what does the law protect? Which prevails over the freedom of choice of a person? What good does this criminal law bring to a person? If this law allowed a person to choose therapy without causing any damage to health, then it would confirm the freedom to choose a therapy other than the officially recognized one. It seems that this law was designed for religions or beliefs that adhere to strict regulations or specific treatments, such as Jehovah's Witnesses, a religion that is known to prohibit blood transfusions for reasons stated in the Bible.
Yes, this is a very relevant issue, and we have experienced it across Europe and worldwide in recent years. Let's move on to the issue of anti-cult organizations, which are gaining more and more power. What role do you think these organizations play in the world, and can they bring any benefit?
The benefit is unlikely. Speaking of anti-cultists, we can distinguish two categories of these organizations. They are the organizations that fight sects and some rationalistic organizations that oppose religions, although their actions are often the same or very similar. In reality, the members and leaders of these organizations are few, and in my opinion, they create a mood of suspicion, if not fear, in society. These fears are always associated with risks to a person's physical and mental health. They instill fear by using truth that lack facts, truths based on their impressions, emotions, or judgments, or on the accounts of former members of the movement, or those who have renounced. Or the anti-cultists take one fact and transfer it to the entire religious community, which they attack as if it were part of their doctrine. And of course, they lie a lot. Anti-cult organizations always give an assessment that supposedly should become the norm. That is, the correct way of behavior, a kind of starting point for comparison. This judgment of normality is the main problem that anti-cult organizations use. Since 2016, with the advent of Q and then QAnon and the explosion of social media, The intolerance that anti-cult organizations impose has found its ally in the face of conspiracy theory. The European Federation for Freedom of Belief has consistently condemned the activities of anti-cult organizations since its founding in 2015. In addition to Jehovah's Witnesses, Christian sects were severely persecuted, and in this case, the term sect is a separation from the larger Christian community. The activities of anti-cult organizations form attitudes of suspicion, intolerance, and of course, anti-democratic sentiments, which become part of a single culture of the world, as opposed to a culture of freedom, which implies compassion, mutual understanding, tolerance, and trust in each other. In the past and at the present time, the activities of anti-cult organizations have led to acts of unprecedented cruelty and numerous innocent victims. In conclusion, I would like to recall what Norberto Bobbio said about tolerance. All should be tolerant with the intolerant, except.
And one more question. To what extent are freedom of conscience and religion, which should be fundamental pillars of a democratic society, respected in today's world?
I would say there isn't much freedom. In democratic societies after World War II, human rights were supposed to prevail. In the post-war period, the dramatic defeat of dictatorial states left the world hopeful for change. With its foundation being Roosevelt's speech in 1941, known as the Four Pillars or Four Freedoms. Freedom of speech, freedom of worship, freedom from want, and freedom from fear. These were meant to become the basis of true democracy. This intention was solemnly formulated and supported by 48 countries in the UN General Assembly in December 1948, in the Universal Declaration of Human Rights. However, the promise of change was never fully realized. It remained a hope and was used as a goal. At the International Conference in Florence in 2018, organized by FOB, Law and Freedom of Belief, An Arduous Path, a lot of discussion focused on freedom of conscience and religion. The difficulties faced by freedom in Europe and the problems of democracy in modern society. In fact, democracy is in deep crisis, and many are aware of the reasons for this. The crisis affects not only freedom of religion, although this freedom remains an important benchmark for what is called true democracy. Western democracies and European countries define human rights, especially freedom of religion, as one of their fundamental characteristics. In fact, the European Union's founding treaty requires the respect of these rights as a condition for joining the Union itself. Article 9, Paragraph 1 of the European Convention on Human Rights, ECHR, signed in Rome in 1950, establishes the centrality of religious freedom. Article 19 of the 1948 Italian Constitution, in turn, states that everyone has the right to freely practice their religion in any form, individually or collectively, to preach it or devote time to it, privately or publicly, as long as it does not contradict public morals. Similar norms exist in the constitutions or founding acts of Western democracies.
Eh sì, questi sono eventi che sono abbastanza conosciuti e che purtroppo dimostrano come sulla carta, diciamo
Yes,
così,
these events are quite well
abbiamo
known.
già capito come
Everything
ordinare
is
un mondo
there,
intendere
but unfortunately,
largo,
only on
non
paper.
soltanto appunto come diceva lei come Europa, quali sono i principi, cosa
We as humanity should already understand that all of this is written in our constitutions, and we only need to implement it.
nella pratica tutto questo non si riesce ad
However,
applicare.
sadly in practice, it is not being fulfilled.
In uno dei suoi
And I have one more question.
anche di un altro
In one of your speeches, you also mentioned another right, the right to truth. Could you explain this in more detail?
come lo può spiegare?
Well, the right to truth is a need that has become inevitable today. Ever more sophisticated electronic systems give us the ability to communicate easily, which means that various data, interpretations, and narratives have entered both private and public life, things that did not exist before the rise of social networks. Today, anyone can communicate with anyone, or with everyone, and they can even do anonymously. The space for lies, facts, and various stories has grown immense. What then is the truth that must be unequivocally guaranteed? And what is the lie that must be punishable? It is the truth that is based on the facts surrounding us. In a sense, we encounter this every day. It's an attempt to understand how things truly are based on facts. And while this seems obvious, the right to truth is not recognized as an independent right in any legal system, nor is lying punishable by law, at least not as an offense. Some legal norms do prescribe punishment in cases such as forgery of official documents or perjury, as well as fraud, deception, or manipulation. But in these cases, truth is not viewed as a right, but as an obligation, and lies are seen as violations of that obligation. The right to truth is not even provided for in the Universal Declaration of Human Rights. Therefore, there arises the necessity for truth to become or must become an autonomous, legalized right. Since December 1948, and considering the 30 articles devoted to rights and freedoms outlined in the Declaration, work has been ongoing on the right to truth, and truth without which no freedom and no right have any meaning. The right to truth is the first and most important of all. It is deeply and closely connected to self-determination, to who a person is. This is not just a legal fact. Self-determination is who we are, each one of us, whether it is a group, association, community, or church. It is all of these. What lies at the foundation of the Declaration and at the heart of the freedoms and rights laid out in the 30 Articles is the protection of a person's self-identification. It is like clothing that covers a person, making them unique and new. In other words, everyone has the right, and no one has the right. And what emerges from this collective will through global struggle is ultimately self-determination. This is why unjust attacks on new religions provoke outrage, as they destroy their self-identification. Those who, with great zeal, claim that these new religions are not legitimate destroy the self-identification of these religions and of their believers. They assert that these religions and their believers do not exist. I remember the trial in the Italian court of cassation, where believers of a new religion also participated. In the final defense speech, it was said that these people, these believers, these women and men, were good people, and the entire trial was built upon this. After the verdict, one believer who was present in the courtroom broke into tears and confessed to me that she cried because her self-identification had been restored. These were tears of relief. This is the meaning of the right to truth for no matter how difficult it may be, because it is a fight for life and freedom.
Grazie per questa spiegazione, perché in realtà
Thank you. Thank you for the explanation. I truly believe that every person is always searching for the truth. It is a path with neither a beginning nor an end, and it lasts a lifetime. How can one find the truth in today's world when the flow of information is so vast that it is genuinely difficult to navigate? How can an ordinary person find the truth?
Well, I will take on this important and rather difficult task. But there is no other advice than to try to track the facts in the flow of information, and then more facts. Don't take statements about the existence of facts at face value. Understand that often what is presented as a fact is actually an interpretation of it. The only way to find the truth is to use multiple sources, compare them, and study them carefully. I'm not a seer to point the way to truth and freedom. I believe that the search for truth, like the search for freedom, is essentially an individual life experience. It is a striving and an attentiveness to understanding what is truly happening in the world and society. And then, even in the continuous flow of information, it will not be difficult for you to see how things really are.
Thank you for your response. The question is really important. It goes beyond the legal sphere and concerns the knowledge of the person himself. In the last question, how can each individual and society as a whole protect democracy?
True democracy, as the rule of the people, probably never existed, except perhaps for a brief period in ancient Athens. Democracy has always been representative. There are referendums as manifestations of democracy. Democracy as a form of government brings together a variety of, and sometimes contradictory directions. It is a wide spectrum, from liberal democracy to oxymorons such as sovereign democracy and illegitimate democracy. And democracy that protects and defends human rights is very scarce, and none of the countries has fully realized it. Even the democracy of European countries often does not protect human rights. Forms of government, that is, democracy, existed in history in accordance with events. I am not a visionary to say how to defend the existing democracy. For formal democracy does not need to be defended, given the vast amount of ideas, ideologies, and harsh news that are being disseminated. Real democracy is the choice of the people. People need to make this choice, and the question is how to preserve and protect it after that. To protect such a democracy, human rights must be protected. There are also civil rights, although the main thing is to protect human rights even in a formal democracy. In some countries, such protection can be dangerous and even lead to death. These observations can hardly be called original, but I have no others. This is only personal experience, and from this, follow two rules that also apply to society. And the rules are as follows. Learn to be your own lawyer and protect your space. This means that you must understand what is happening in society and observe it from the outside. Protecting your personal living space, rejecting any ideology, any judgment, any statement that goes against your values. It is necessary to deter any attack, no matter where it comes from. I have nothing more to add.
Thank you, Mr. Lawyer. This has been a truly profound and very interesting interview. I thank you for everything, and I hope that we can meet again in the near future to discuss other issues. Thank you, and see you.
Thank you.